Thank you for staying with us. Dr. Ubani joins us, as you've seen on the welcoming slide. He is former chairman, section of Public Interest and Development Spittle of the NBA. Thank you so much for joining us this morning.
Thank you. I am Buki.
It would seem like the current CGN is in cahoot of sorts with the former CGN, Mohammed Belgore, when he said, because the judiciary is misunderstood, Nigerians do not see that it is the one arm of government that is actually serving the people. Those who hold the judiciary as part of the Nigerian problem either do not know or have refused to pay attention to the fact that even the judiciary is subject to the laws of the land, the ground norm being the 1999 Constitution of the Federal Republic of Nigeria as amended. Tailing what the CJN said there right now, that the noise of social media and all those other things have attempted in recent years to put the judiciary in some position or image that isn't it. But then, looking at facts, looking at precedents, one would wonder whether or not there is need for judicial education, or that the judiciary is actually serving itself and other people.
The position of thing is that what he's trying to say is that the judiciary is trying its best. And the circumstances under which the judiciary operates in Nigeria is very, very frustrating. Very, very frustrating in the sense that most of the basic things they require in order for them to be very efficient are not there. I was in court yesterday, Court of Appeal to be precise, in Lagos. I woke up by 4 because, you know, if you want to go to through Third Mainland Bridge, you have to wake up very early. I did. Getting to the court, my mother was called. And my Lord reminded me that it is for application. I said, no, we don't have any pending application. It is for adoption of our briefs. He said, no. They are overworked. Because if he takes me now, within 3 months, he has to give judgment. Looking at the number of cases they have already adjourned for judgment, there are too many. When I persisted, my Lord was telling me that 2 of the judges of the Court of Appeal are in the mortuary. He told me that. They're overworked. How can you have 2,000 cases for Court of Appeal alone in Lagos, and you have only 2 panels? Lagos is a commercial city. Why is it that we are not having different panels, maybe up to 4 or 6 panels in Lagos? So he was crying. They're overburdened. You go to Supreme Court, the same thing. So the circumstances, you know, under which they operate is so bad. So they are doing the little they can in order to serve, but they are not getting probably positive reaction from the people because people are seeing them in bad light, but they don't have that right to speak out, to tell you what they are also undergoing in terms of suffering, funding, and some other interferences. So that's the issue.
But besides the pressure that the judiciary is going through, which is appreciated, is this continuous reference to public opinion, which we also saw during the presidential election petition court during the delivery of the ruling by one of the judges. I imagine that, you know, every other professional or profession goes through one form of pressure or the other. I imagine if as broadcasters, you know, we're distracted by pressure, we'll not deliver, you know, on the job. Why do you think the judiciary continuously makes reference to this challenge of public opinion? No,
you see, we are now under a new era, you know, the social media era, you know, and technology. Unlike previous times that these things can be probably spoken in your bedroom and nobody hears. Everyone now, you know, has a handle. So whatever he feels like, he can say it. And judiciary is in the eye of the storm because, one, we are in political era, you know, season, where most of the cases now are being tried by the judiciary. Are you following me? So they should expect those comments. They should expect reactions from people. We are not in 20th century, where this is 21st century, where the social media, different from the normal media and all that, you know, so they should expect all that.
That's the judiciary.
But we as judiciary should expect all that. But what he's trying to say that, look, we are not going to be bound by your opinion or sentiment. We need to apply the law, and we have laws. So I don't expect them to apply sentiment, in reaching their decision. It is the law of the land. There are enactments, there are procedures. We have procedural rules, we have substantive laws. So what they will apply is the law. And what he was only, saying the obvious. He wasn't saying anything that is different. But the point is that I must also advise them to expect certain reaction from the people. The fundamental human right of freedom of expression is there, and they have to express themselves. But in expressing themselves, they must also be careful not to in any way malign the judiciary. That is what he's trying to say.
So in maligning the judiciary, talking about that, some of these issues that people have with the judiciary is what they sometimes consider, wait, how can this be? For instance, the case involving the governor of Imo State today, there are those who cannot fathom in their heads how someone who placed third or fourth in a particular election is now, pronounced by the court as having come first. A situation of the former president of the Senate who initially said he wasn't interested, and then his party, went to court and a judgment came, and now he is a substantive senator. Those are examples of cases that people are wondering, how can these things be? It also goes back to the judiciary. And I think you have also complained about it at some point, that it should be the ballot box that will determine who becomes whatever in this country, and not the judiciary. But of late, it has been the judiciary. So when you say they are overworked and all of it, is it because they are overworked that these things are happening?
It's a very, this is a technical question. And I don't know whether I will give you a technical answer.
Please, let's avoid all
The point is that our substantive law have allowed the judiciary to actually intervene in our electoral process as being the final, arbiter. So if there are irregularities at the polling unit and you have a grievance against the electoral outcome, you have a right to approach the court. So they will be the final to determine, unfortunately. But the point is that we're overburdening them, and we are saying, can we create an electoral system in which the fairness of that process will be guaranteed, so that you determine who becomes a ruler, at the polling unit, so that we don't overburden the judiciary now having the final say, and at the end, people will become more, aggrieved, that the judicial system itself have not dispensed justice. Now, issue of they are human beings still. Blood and water runs, in them. They are not angels. That, again, we must emphasize. So the issue of error can also occur. You must understand it. Unless we're thinking that these judges are gods, they are gods in heaven who do not make any mistake. As long as they are human beings, they are not infallible. They are not infallible. Well, so it is important we know that. So if you mention the Uzodima's case and some other this and all that, some people feel that judgment, all those judgments, that they don't feel that it is the right judgment. But if you look at if you read the substantive cases, you will see the reasons also given why those things were, reached at that point in time.
Well,
so it's important.
They are human beings. Yeah, a similar thing is brewing now with this certificate saga, because a good number of people are going to be wondering how is it going to,
be determined. Yes.
On the one hand is the fact that from what we know, you may want to educate us further, that the Supreme Court rarely takes on new evidence to decide on a matter unless it is compelling. On the other hand, there are those who are wondering whether or not this judgment, as you have said, may not go in the direction of a technicality. First of all, do you see this, what we have, as being admissible at the Supreme Court?
The matter is presently pending before the Supreme Court. So whatever discussion I will make over this, I have to be a bit careful until they determine it. But looking at the facts surrounding it, the issue of admissibility of fresh evidence, by the appellate court is very rare, especially if that particular evidence was available to you while you were initiating the process. The Supreme Court will never, even the appellate court, other court of appeal, would not admit any fresh evidence, because their job is to review the decision of the court below and not to now evaluate any evidence. They don't take any evidence. But there are special circumstances under which fresh evidence can be admitted by the court of appeal, by the appellate court. And that ground is that maybe at the time you filed the case, that evidence was not available.
But this was not available at the time the case
Now,
was
when
filed.
was he initiated? When was he initiated for the availability of this document? This will be taken into consideration. Did you initiate this process after the final decision of the court of below? If you did, why didn't you probably start earlier in order to get it? It wasn't available. So the court will take all that in, because facts differ. Okay. And they decide their case based on, and also issue of admissibility of that fresh evidence is very critical. You must convince, and whoever is bringing it will be opposed by the other party. So the court now exercises what called discretionary power in either admitting or not allowing that fresh evidence to come in.
But where are you in all of the discrepancies identified in what was released by Chicago State University and what was submitted to INEC?
Yeah, my opinion will be made known fully after the Supreme Court would have taken a position. But the point is this, under our law, if you present what you call forged document to INEC, under Section 137, if you remember, it is a ground for disqualification. It is a ground for disqualification, but you must prove forgery because now he has entered into the realm of crime. So it is issue of proof beyond reasonable doubt. So the evidence, the burden of proof lies squarely on the petitioner. It's a very heavy burden.
Okay. Chamberlain.
Mr. Ubani, that is going to be very interesting, that section 137J, grounds of disqualification. But you start, at some point, you mentioned technicalities. But in what circumstances do you think technicalities can come in again on this particular matter? Because to a lot of people, they think it's as clear as black and white.
It's not very easy. Because as the CJN has already pointed out, the thing that will be applied is going to be law. And not sentiment, So if you are saying that it is forged, the point first and foremost is who says it's forged. The best evidence will only come from the school where that certificate is domiciled or came from. And so what did they say concerning that certificate, So they will look at the facts. What is the university saying? Is the university saying pointedly that that certificate that has been submitted to INEC didn't come from them, that it is not their certificate, and that there is no other source where it can come from? Yeah, because I'm hearing, we are hearing this issue that there is a particular body that can also issue any law certificate from the university. Does the university say that they don't have such a body? So if the university has not expressly pronounced that certificate forged, then it will be very difficult for anyone to say that it's forged. So the onus lies on the petitioner now, or the appellant, to say, look, I have been able to prove that this certificate conclusively is forged, and the university has said so. But the university has left a lot of gaps.
But Mr. Ubani.
Yes.
If the university says the certificate that we usually have is this, maybe type A, and then if they then say, look, the type B or whichever type is in your INEC or whatever you call it, we don't know about that. This is the one we know. What other expressly speaking, which other way can it be expressly put other than telling you, well, this is the one we have? So we don't know about any other one other than ours.
Sorry, that if a certificate get lost, that one, that they don't have a copy of it, and then there is this particular story that other bodies can also issue on their behalf. I don't know whether it came from the university or from, from the respondent, because I heard that story that if you lose your certificate from that university, you have a right to apply to another body that we give you that is affiliated to the university. I heard that story. So those line of argument is something that will be brought before the court. Because as I said earlier, the most important thing is for let the university say, this certificate you have presented is forged. That has to come from the university. If the university does not say so...
Let me hypothesize a bit.
Say it again.
What if the two circumstances here, just playing out as you were speaking, does the petitioner have to go to court with whatever they have from wherever they get it and ask the court or the school, this particular document, is this from you? And if that happens and the school says, this is not ours, the one we issue is this one, but this other one is not ours. And assuming we got that one from the country here, and the school has disowned that one, would it be tenable in the court here that the school has said they don't know about this one that we brought from here to them?
The legal team of the appellant is really doing their work now. And I can assure you, that the legal team of the respondent are also looking at the situation dispassionately in order to know what to respond, when these things come up before the Supreme Court. These things will be presented. The facts are very clear, keen, and they will be interested in looking at the facts in order to now persuade the Supreme Court to reach a particular decision. So whatever we do here, without having the full facts of the case, may not be able to help even our fellow citizens. Yes.
I asked the question based on what you said, because you said there was a narrative that came through that if you lose your document, you can apply to another body. Now that's what I'm saying. Look, assuming we would consider that is the case, if that happens, and then we go with the one, quote unquote, that may have been issued by another body, in quotes, to the school, and the school says, we don't know about that one. What else will the school be required to do? Wouldn't that be tantamount to saying, we don't know about any other thing apart from the one we issue?
But this is speculative. Now, the school has not said so, Chamberlain. As I said earlier, the best evidence will come from the school, but the school has to be the one to speak to whatever, our president has presented before INEC, because the law says it's only forged document presented to INEC that can be a disqualifying factor based on forgery. Document forged. So as I said earlier, the proof of that forged document lies squarely on the appellant. And he can get that particular evidence from the school. If the school has not said so, it will become very difficult for anyone to now call that document forged. It's going to be a very onerous task.
Has already said, spoken about their own kind of certificate.
Who has spoken about their own certificate? You mean the school?
Yeah.
I didn't get the answer. I didn't get the question.
About the certificate they issue.
Now,
the school already spoke about the ones that they issue. It's clear. Everybody is out there.
That is what we're saying, Chamberlain. The court will look at all the facts of the case. Because my thinking before, when Atiku was pursuing this, was whether he was looking at the fact whether this our president did not attend that university. The university has come up to own up and say this person was our student. He graduated from our university in 1979. He passed through the Department of Accountancy, and we issued a certificate, a degree certificate. In other words, you cannot disqualify the president now on grounds of education because he passed through a university and got a degree. Now, the only issue now is the certificate he presented. Was it from the school? Because I hear it was diploma that he presented. If he presented a diploma, did the school give him diploma certificate? That is the issue. And the Supreme Court will decide all that based upon whatever Atiku and his legal team will present before the Supreme Court. They will look at it dispassionately and be sure that what they will apply is law. You hear the CJN say it. We are not going to be bound by sentiment all over the social media. We will look at the state of the law and apply what the law of the land has said. And we have to hold them tenaciously to it that all what will be applied is law. So then let's not dissipate energy of whatever is going to happen. We trust the Supreme Court, men and women that are learned, people that have integrity, people that we know over time have had experience from the lowest court to Supreme Court. Before you become a judge of the Supreme Court, it is not a day's job. Experience over years. So we must trust them to dispense justice, to all the parties that will appear before them. That is my statement about this, my brother.
Even though you also said that the lawyers, the judges themselves, they are not infallible. Whether that will play out or not, I guess we'll have to see, wait and see.
That's correct.
Dr. Monday Ubani is former chairman, section of Public Interest and Development Spittle at the NBA. Thank you again for your time this morning.
Thank you, my brother. Ayo, what we want to emphasize is that let's help the judiciary. Issue of litigants going to court for years, 10 years, 20 years, the matters are not resolved. The governors, the president of the country, the attorney general, we must all wake up. Lawyers are complaining. They go to court, they don't get justice.
Well, since we know that the judges cannot do it themselves, maybe NBA needs to pay some money to Channels Television so we have a weekly. Well, some of your own comments here on this program, it's Henry Awunanu, yours is coming first, and it says about the handling of Lawal's slump at NC at the Senate. This incident, as shown in the video, has once again revealed the poor depth of knowledge of handling medical emergencies in the general population, though it's expected that the National Assembly would have had a better medical emergency response system. Let the National Assembly commence trainings on basic life support for all the members and staff, beginning first with the sergeants at arms. Let all the public places, including churches, mosques, markets, high-capacity buses and trains, be equipped with defibrillators that can restart an arrested heart. There should be a multi-stakeholder involvement in deepening health education in our nation, especially periodic medical checkups. Can we do better next time?
Well, we see your mail, Eka Dixon, Victor Owo, Oshinawa Kinsley. Thank you very much for sending them. We do appreciate them. We'll take more of your mails next time. I'm afraid we're totally out of time. That will be all on the program today. Thank you so much for watching. I am Bukola Koka.
I'm Ayamakinde. Have a wonderful day.
Thank you. From this end, don't forget to go for that fitness check if you just haven't. I'm Maokwe Yusuf.
And I am Chamberlain, so goodbye.